Because patents grant the right to exclude their valuable, patents can be licensed to other entities in order to generate a revenue stream. And a company's patent portfolio is considered a crucial part of the company's assets. Patents can be instrumental for fundraising, they can be leveraged in business transactions, and they can be essential in mergers and acquisitions. And finally, another benefit is the patent pending marking and the marketing benefit. As soon as a patent application is filed, before it ever issues as a patent, a product covered by the patent application can be marked as patent pending immediately and for the duration of the pendency of the patent application. Once a patent application issues as a patent, a product covered by the patent can be marked with the issued patent number. Even if the patent application never issues, the words patent pending can be used until the patent application is abandoned. This can be a marketing benefit to afford greater credibility and to establish a company and an inventor as an innovator in the field. And it can also deter competitors from copying even before any patent rights have been granted. So sometimes people pursue patent applications even when they're uncertain about what patent rights they may eventually receive in order to receive some of these marketing benefits. Okay, when is an innovation patentable? So the barrier that you have to consider when you're trying to determine whether your innovation is patentable is what we call prior art. In essence, what is considered innovative enough to qualify for patent rights is defined relative to what was already known in the technical field. Prior art is typically something that was publicly available before the effective filing date of the claimed invention, such as a patent, a printed publication, a public use, or a sale. Prior art can also be something that's disclosed in a patent application or a patent that, although not necessarily publicly available, was filed before the effective filing date of the claimed invention. So, if you want a takeaway from this, it's that filing sooner is typically better because it minimizes the amount of prior art, since prior art is defined relative to the filing date. Then, after you understand what prior art is, you have to understand basically the two main ways that prior art is used. In order for a claimed invention to receive patent protection, the invention must be both novel and non-obvious relative to the prior art. What exactly does that mean? So a lack of novelty is when an invention has all features in its claim present in a single prior art reference. So what that means, for example, let's say that you want to claim an additive manufacturing technique where a spool of material, such as thermoplastic polymer, is pushed through a heated nozzle in a continuous stream and selectively deposited layer by layer to build a 3D object. I hate to break it to you, but you are not going to be granted a patent on such a broad invention because material extrusion already exists. So in that case, we would say that your alleged invention lacks novelty. Then turning to obviousness, an invention is obvious when the differences between the claimed invention and the prior art are such that the claimed invention as a whole would have been obvious before the effective filing date of the claimed invention to a person having ordinary skill in the art to which the claimed invention pertains. So that is really just somebody who works in the space, is familiar with the space, knows what is going on. More than one reference may be combined to find a claimed invention obvious. For example, and this is a very basic example, so bear with me. Let's say that you now want to claim a 3D printed bowl. For the sake of argument, let's assume there's no prior art showing a 3D printed bowl. However, let's also assume that 3D printing exists and bowls exist. Your patent application will almost certainly be rejected for being obvious over the combination of known bowls and known 3D printing techniques. I think this is an important thing to know if you are considering applying for a patent application, because merely 3D printing a known product is not going to be sufficient to get you any rights. So there really needs to be something more going on. How do you assess whether there's something more going on? Here are some questions that I would consider if I were in your shoes. How Has your device never existed before? Because traditional manufacturing would not be capable of making it. In some cases, 3D printing allows very complex designs or designs of something that is unitary as opposed to being made of multiple parts, and traditional manufacturing would not have allowed such a design. That would be a sign that perhaps there's something there that deserves additional review to see whether a patent application should be filed. Another question to consider: have you altered the parameters of an additive manufacturing process and obtained unexpected results? Is there something different about your process, something unexpected that nobody was really looking to do or expected to have happen? That would be something to consider. Are you using a material that is newly developed or was previously considered inappropriate for use in additive manufacturing? New materials can be a great source of patentable subject matter. And another question to consider are: have others tried to make an invention similar or the same as your invention, but been unable to do so? Have you come up with a unique design or a unique process that has enabled you to do something that has been needed, but has never been able to be made previously? Obviously, there are additional considerations. I would encourage you to consult with a patent attorney if you have questions. I'm happy to answer sort of broadly any other questions that people might have about this. But this would be generally my starting point if I were an innovator looking to assess whether it's worthwhile to spend the money on patent application. Okay, so let's say that you have decided that you are going to proceed with pursuing patent protection. When do you need to proceed? That's the next question that's going to be important. So what you need to know is that your ability to file a patent application is going to be impacted by the public disclosures that you make. And so if you are disclosing in any way, if you are offering for sale, making a sale, having a public use, or if you are publishing, these are all actions that could impact your ability to pursue patent protection. And so you need to be conscientious about those, and you need to be aware of what the timeline would be. So in the United States, we are fortunate to have a grace period. What that means is that you have 1 year after a public disclosure before your public disclosure will be considered prior art to your claimed invention. So hopping back to what we talked about before, if your own product is prior art and you file a patent application directed to that product, and your own product is then cited against you to say you lack novelty, that's a very difficult situation to overcome. And I understand that it sounds a bit technical and confusing, so I'm happy to explain again. But the crux of the matter is that you really do not want to be in a position where something that you have publicly disclosed and are trying to claim in a patent application is more than 1 year in the United States before you have filed your patent application. Abroad, this may be even more stringent. Many foreign countries, particularly European countries, do not have a grace period. And so you need to be filing a patent application before you have any sort of public disclosure. I also want to just make a note here on attorney timing. I'm saying that you have a year after public disclosure in the United States, that you should file foreign before you have any public disclosure. But another thing to keep in mind in terms of timing is that any attorney you work with is going to need some amount of time to prepare a patent application for you. They're typically documents that are anywhere between 15 and 50 pages, sometimes slightly less, sometimes more. And most patent attorneys will do them on a rush basis, but you are typically going to have a higher quality patent application if you give your attorney at least 6 to 8 weeks to perhaps do some searching, to draft, to get formal figures, and to file the patent application. So I would recommend contacting a patent attorney before you have any public disclosure, or as soon as possible thereafter, to ensure that you are having as much time as possible to analyze and file any patent protection. Okay, so you filed now, you hit that timeline. How does your application become a patent? An application is really just an opportunity to get rights. It in and of itself does not give you any rights. In order to have rights, you have to actually reach the point where the patent office issues your application as a patent. How does that happen? Well, the first thing to know is that the claims are what define the rights. A patent application includes drawings, it includes a specification describing and explaining the invention. It can sometimes be quite a long document, but the claims, which are at the back of the document, if you have a physical copy, or if you're on Google Patents, you can see it on the right side. Those are what define the legal rights. And what you should understand is that patent prosecution is a negotiation of those claims with the patent examiner at the US Patent Office. The purpose of the examiner is to protect the public domain, to not give away rights that people should be able to use freely and publicly. And of course, the purpose of the applicant is to get as many rights as they can for their own monopoly that they feel they're entitled to because of their efforts. So this is a negotiation process, and during examination, an examiner typically issues rejections based on the prior art. And in response to those rejections, the applicant can amend the claims, typically narrowing them to be maybe slightly smaller or to distinguish around references the examiner has identified. Or the applicant can argue that there are differences and the examiner is mistaken or misinterpreting the art that has been cited. So office actions. The examiner's rejections are provided in an office action, which is a document that is mailed out. It is typically 10 or more pages. It describes what they are citing, what they consider the prior art, and why they are citing it. Once that is received, a response typically has to be filed within 3 months, and extensions of time are available for a fee, and the fees are based a bit on the size of the company. So there are some discounted fees if you are a small entity. And the initial USPTO application fee, the fee that you pay to the patent office when you file your patent application, covers the cost of 2 office actions. And sometimes that's sufficient to reach issuance as a patent. Sometimes prosecution proceeds faster, or sometimes there are more office actions involved, which typically involves more fees being paid to the US Patent Office. Okay, issuance. So you've gone through this negotiation. You and the examiner are in agreement on the scope of the claims. When that happens, the application then proceeds to issuance as a patent, and it has legal rights that are defined by the agreed upon claims. And those are the rights that you can then take to, for example, a federal court to enforce against a competitor and prevent them from copying your device or obtain damage payments if they have already been copying your work. That is when you can proceed to that stage after you have the patent rights. Abandonment is when there's no agreement reached with the examiner. So the application eventually is abandoned and there are no legal rights that result. Obviously, that's typically not desirable. Occasionally, people are comfortable filing applications that may have to be abandoned for the marketing benefits that we discussed earlier. But typically, people only want to invest in patent protection if they're actually going to reach issuance. And this is why, in my opinion, it's really important to work with an experienced patent practitioner who can help you assess whether it's worth filing a patent application and who is going to draft a high quality patent application that is going to have sufficient support for your innovations and have sufficient fallback positions that allow you to eventually find at least some claims that can be issued as patent rights. Who should file a patent application? So one of the main reasons that I wanted to come and give this presentation is because in October, the USPTO issued a report talking about women as inventors. And one of the more startling statistics that I read in this report is that women make up only 13% of all inventor patentees in the United States. This rate is significantly lower than other marks of women's education and employment in science and as engineers. So what that means is that it's not simply a pipeline problem. This doesn't just reflect that there are not 50-50 representation of men and women in science and technology fields. It also represents the fact that women's innovations are being patented at a lower rate, at least assuming they make comparable contributions, which I think is a fair assumption. So what is the effect of this? I mean, some economists, according to this USPTO report, suggest that if women were to patent at the same rate as men, commercialized patents could increase by 24%, and per capita gross domestic product, that's the total economic output adjusted for the US population, could increase by 2.7%. Women's experiences and viewpoints also inform and improve the quantity and the quality of inventions, and gender diversity expands research into under-researched topics and can thereby fill overlooked technology gaps. So as you would expect, as it is in most cases, having a broader variety of people involved in a process results in a higher quality outcome. And for our society, that would mean a higher quality outcome where women's problems and women's ideas are receiving the same commercial benefits that patenting provides for similar ideas that men come up with. So who should file a patent application? Possibly you. If you are at this conference, I assume there's a great chance that you are an innovator and you are working in this space, and you should really be considering whether you should pursue patent protection. If you're looking for resources, the USPTO and the Department of Commerce recently launched an Empowering Women's Entrepreneurship, WE, initiative, and it has an online hub, and I have provided the link there. There are resources there that can answer some questions and direct you to government support. And also, I would be happy to answer any questions. I will be around after this presentation. I know this was rather high level. I wasn't sure how much familiarity everybody would have with patent law generally. So I'm happy to take questions now. I'm happy to answer anything more specific, less specific. My email address is there. Please feel free to contact me anytime. And that's it for me.
Thank you so much, Kate. That was so interesting, and I appreciate the stats and the resources as well. We do have a couple questions from the chat for you. So the first one is, how much do patents cost in the additive manufacturing space?
Yeah, that's a great question. So typically the cost of a patent application will depend on the complexity. So it depends how many different products are you looking to include. I would say typically you're going to expect it to be somewhere between $7,500 and maybe $17,500 in terms of dollars just for the patent application. I would put an average a little lower than that, maybe 10 or 12. But you would really have to consult with a patent attorney to get that information because it is going to depend greatly on the complexity of the product. And then that's for filing the patent application. There are additional costs associated with prosecuting it to allowance to where it actually issues as a patent. Those costs are hard to anticipate ahead of time because, as I mentioned, you may only get one office action, you may get 4 office actions. It fluctuates a bit, but there are additional costs assumed after you file a patent application, typically not for a period of time. Typically the patent office is busy. They may not even pick up your patent application for review for a year or so. So there will be some time before those additional costs are incurred. And I didn't go into it in my presentation, but you can file what's called a provisional patent application where examination does not start for a year. And so then you would have a full year where you know that there's not going to be any further costs or examination before you would then file a non-provisional to begin the examination process. I'm sorry, I'm not hearing you.
Sorry about that. The question is, how do you determine a quality patent firm when deciding on which firm to choose?
Yeah, that's a great question. I think that there are a few ways you can tell. I would typically look to see how long the firm has been in existence. I would talk to people who you trust to see who has been filing patent applications. In general, I would ask your attorney. It's an interview process. You're hiring them to do work for you. So you should be asking, how many patent applications have you filed? Have you worked in this space before? How many years have you been practicing? You can look at their educational background to see if they have a technical understanding of what you are working on. And you can ask them the way you would ask anybody that you are hiring to do work for you.
Yeah, I think that's good advice. Jumping back to the costing, there was a follow-up question on what if you can't afford a patent? Are there other resources for financial support?
Well, so, one of the ways to really keep costs down is that you can file a provisional application. And typically, we would prefer as patent attorneys to draft the full application with drawings and claims and everything, because that is the best way to protect all of your innovations. However, if you're in a position where you really just want to draw a line in the sand, it's possible to file a provisional application with just disclosure materials, drawings, your own written explanation of what you have come up with. And then you would have 1 year from that time period before you would need to convert that and have a full patent application prepared. And so the best, that's something that can be done for a much lower cost. I would say, a couple $1,000, couple $1,000, something around there. And so that would be a great way to minimize the cost as much as possible. There aren't really, you might be able to find some organizations that are willing to provide support, but that would be more of a traditional business situation who wants to invest in your company than any sort of scholarship program for patent applications. I'm not aware of anything like that.
That's a good strategy, though, to go for the provisional and then have some time to get your funding together. The next question is, do you see an application for blockchain technology to secure IP moving forward? They give an example.
Yeah, I haven't worked on blockchain, but certainly people at my firm do. Another thing to consider when you're talking to your patent attorney is what is their technical area. Blockchain is not my technical area, but that is something that is patentable in certain cases and is something that you can inquire about getting patent protection for.
Okay. How do you highlight your own existing prior art to protect yourself from another party filing a patent for something you've already made, but you don't want a patent?
There are actually ways to submit a third-party disclosure to the patent office. So if you are very concerned that the patent office is not seeing something that they should be seeing, you can consult with a patent attorney, and there are actually ways to have that submitted, and in some cases submitted anonymously if you don't want to have it known that it is you submitting art against your competitor's patent application. Though obviously if it's your own product, that it may be difficult to maintain anonymity in that situation.
Okay. Well, thank you so much for joining us. Again, Kate's going to be around for networking. And if you want to put your contact information and your web address in the chat, that would be great. Catch Kate in networking to talk in more details about the patent process. Thank you so much for joining.
Thank you so much for your time. I'm excited to be here, and I can't wait to hear the rest of the speakers.